Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in my three previous sessions, we have discussed the trial in session court, trials in warrant cases and trials in summon cases. One common thing that we have observed in all those trials is there is a lot of procedures involved in all those trials. But can we invest so much time for all the cases? Answer is no, because there are so many cases pending in Indian courts. With that, if we start doing all those procedures in small petty cases, then we are going to eat all the time of the court. To avoid that, there is one beautiful chapter in CrPC, which is chapter 21, which is from section 260 to 265, deals with summary trials. Summary trials are speedy trials. We cannot spend too much time for all these small cases also. So there are a list of few cases where we can have trials with 1 or 2 sessions or maybe 3 sessions and close them. So that is all about summary trials, which I am going to explain all these 6 sections in one single slide, which is my next slide. As I said, there are 6 sections under chapter 21 of CrPC which are dealing with the summary trials, and the first 2 sections are dealing with who can conduct summary trials. Now, section 260 deals with Chief Judicial Magistrate, Metropolitan Magistrate and Magistrate of First Class who can conduct summary trials whenever the punishment is below 2 years. Now, the examples for all those sections which are covered under 260 are the theft cases which are under IPC section 379, 380 and 381, where the theft value is less than 200 rupees, or receiving concealment of stolen property which are discussed under 411 and 414. Again, the value is below 200 rupees. And lurking, house trespass and breaking house, which is discussed under IPC section 454 and 456. And intimidation or criminal intimidation under IPC section 504 and 506, or abatement of any of those offences or attempting of any of those offences, or offence under section 20 of Cattle Trespass Act 1871. All those cases can be done summary trial by CJM, MM or Magistrate of First Class. Now, summary trials can also conducted by the Magistrate of Second Class with the confirmation of High Court wherever the punishment is less than 6 months. Now, remember that the confirmation of High Court is one of the must requirement, and after that the summary trials can be concluded by Magistrate of Second Class. Here, all abatement or attempt of committing of any offences which are having punishment of less than 6 months can be summary trial by the Magistrate of Second Class. The next important question is procedure. I said there will not be too much of procedures as per the code of session or warrant cases or summon cases, but the procedure to be followed in summary cases is equal to the summons trials, but it will not be so lengthy because there will be not that much of recording as comparing to summon trials. Now, one important thing that you need to remember here is the punishment given under summary trials cannot be more than 3 months. What if it is more than 3 months? The case needs to be referred to the higher courts. That is what you need to remember. Now, section 263 is one of the most important section because there can be an independent question on a short answer question, which is record in summary trials. How are the records maintained? Now, there are A to I points I have given, which is according to the Act. First, you have to have the serial number of the case, then date of commission of the offence, then date of report of the complaint, then name of the complaint if any, then name, parentage and residence of the accused, then the value of the property, which in case of 379, 380 and 381 is less than 200 rupees or is equal to 200 rupees, and receiving concealment and stolen property, the value should be is equal to or less than 200 rupees, then the plea of accused and his examination, then the findings and the sentence of the final order or date of termination of proceedings. These are the record which need to be available in summary trials. Now, if any case, if summon case where accused does not plead guilty, then judgment in cases of trial summary should be available, where judge need to mention the substance of the entire evidence along with his judgment with brief statement of the reasons for his findings, as per section number 264, and section number 265 deals with language of records, which needs to be the language of the court. Now these are the 6 sections which cover the summary trials. If I have to sum up the summary trials in 1 minute, the first section, that is 260, deals with the power of summary trials given to the Chief Judicial Magistrate, Metropolitan Magistrate and Magistrate of First Class wherever the punishment is below 2 years, mostly of theft and concealment of properties under IPC sections where the value is less than or is equal to 200 rupees. 261, where High Court gives permission, the Magistrate of second class can conduct summary trials when the punishment is below 6 months. Now 262 deals with the procedures to be followed, which is equal to the summon cases. The punishment cannot be go more than 3 months. That is what you need to remember when it comes to 262. 263 is one of the important sections where you have to mention how the record is maintained. 264, whenever judgment is given, if the person is not agreeing the guilty, in that case judge has to mention the major observation of the cases and the evidences and reasons for his judgment. And the last section deals with the court language, that is of the language to be used as per the court which is regularly using. This is all about summary trials. With that, I am concluding this particular session. Thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for your exams or whatsoever purpose you are watching this video. And thanks so much again.